The following are some other instances of this kind of provision in order of date. The Electricity Supply Act 1919, Section 34, provides 1. The Board of Trade, now the Minister of Transport, and Electricity Commissioners may respectively make rules in relation to applications and other proceedings before them under this Act, and to the payments to be made in respect thereof, and to the publication of notices and advertisements, and the manner in which and the time within which representations or objections with reference to any application or other proceedings are to be made, and to the holdings of inquiries in such cases as they may think it advisable, and to the costs of such inquiries, and to any other matters arising in relation to their powers and duties under this Act. 2. Any rules made in pursuance of this section shall be laid before Parliament as soon as may be after they are made, and shall have the same effect as if enacted in this Act. Section 16, subsections 1 and 2 of the Gas Regulation Act 1920 is in practically the same terms as the foregoing Section 34 of the Electricity Supply Act 1919, omitting the reference to the Electricity Commissioners. The Unemployment Insurance Act 1920 provides, by Section 35, subsection 4, that any regulations made by the Minister of Labour under the Act shall have effect as if enacted in the Act. The Housing Act 1925 provides for the making of improvement and reconstruction schemes by local authorities and the compulsory acquisition of property comprised in such schemes. The schemes require the confirmation by order of the Minister of Health, and by Section 40, subsection 5, it is provided that the order of the Minister, when made, shall have effect as if enacted in the Act. Finally, in several recent statutes, a provision is to be found which may be described as the conclusive evidence provision, a provision for which there would appear to be no possible justification. The first three subsections of Section 39 of the Small Holdings and Allotments Act 1908, which were a reenactment of Section 26, subsections 1, 2 and 3 of the Small Holdings and Allotments Act of the previous year, are as follows. 1. Where a council of a county, borough, urban district or parish propose to purchase land compulsorily under this Act, the council may, subject to the provisions of Part 1 of the first schedule to this Act, submit to the Board of Agriculture and Fisheries an order putting into force as respects the land specified in the order the provisions of the Lands Clauses Acts with respect to the purchase and taking of land otherwise than by agreement. 2. Where a council propose to hire land compulsorily, the council may submit to the board an order for the compulsory hiring of the land specified in the order for a period not less than 14 nor more than 35 years, and the provisions of Part 1 of the first schedule to this Act shall apply to the order in like manner as it applies to an order for compulsory purchase, with the substitution of hiring for purchase, and with the modifications set out in Part 2 of the schedule. 3. An order under this section shall be of no force unless and until it is confirmed by the Board, and the Board may, subject to the provisions of the first schedule to this Act, confirm the order either without modifications or subject to such modifications as they think fit, and an order when so confirmed shall become final and have effect as if enacted in this Act, and the confirmation by the Board shall be conclusive evidence that the requirements of this Act have been complied with, and that the order has been duly made and is within the powers of this Act. Under the first schedule to the Act, the compensation to be paid for compulsory purchase is, in default of agreement, instead of being determined by arbitration in the usual way, to be determined by a single arbitrator appointed by the Board of Agriculture and Fisheries, and in the case of compulsory hiring, the amount of rent, in default of agreement, is to be determined by the valuation of a single valuer appointed by the Board. In 1909, the effect of the above-cited subsection 3 of Section 39 was considered by a divisional court in the case of Ex parte Ringer, reported in 25 Times Law reports at page 718. Mr. Ringer was a farmer, and for the purpose of providing allotments, an order had been made by the County Council and confirmed by the Board of Agriculture and Fisheries, empowering the County Council to purchase compulsorily one of his farms which he wished to retain, as being necessary for the profitable working of his other farms. An application was made to the court for a rule nisi for a writ of certiorari to bring up the order to be quashed, on the ground that it was clear that the Board had not given effect to the restriction contained in Section 41, subsection 2 of the Act, which is as follows. A council in making, and the Board in confirming, an order for the compulsory acquisition of land shall have regard to the extent of land held or occupied in the locality by any owner or tenant, and to the convenience of other property belonging to or occupied by the same owner or tenant, and shall, so far as practicable, avoid taking an undue or inconvenient quantity of land from any one owner or tenant, and for that purpose, where part only of a holding is taken, shall take into consideration the size and character of the existing agricultural buildings not proposed to be taken, which were used in connection with the holding, and the quantity and nature of the land available for occupation therewith. In delivering judgment dismissing the application, Mr. Justice Darling, as he then was, said, "The section gave to an order made by a public department the absolute finality and effect of an Act of Parliament. Here there was a public department put in a position of absolute supremacy, and they could only say that Parliament had enacted only last year that the Board of Agriculture, in acting as they did, should be no more impeachable than Parliament itself. Mr. Justice Jelf said that the case presented an illustration of the length to which Parliament had the right to go in ousting the powers and jurisdiction of courts of law. If a majority in Parliament were successful in passing an Act of Parliament which had that effect, then the jurisdiction of the courts of law in matters in which some people might think it was desirable that even government departments should be under control of the courts was nevertheless ousted, and the court had no power to interfere with the decision of the department. Now, is it, or is it not, tolerably certain that the majority in Parliament were not aware of any such provision in the bill when they passed it, and that very few of those who were aware of it had any knowledge of its effect? To provide that the confirmation of an order by the Board should be conclusive evidence that the requirements of the Act had been complied with, and that the order had been duly made and was within the powers of the Act, was a direct encouragement to the Board to disregard the requirements of the Act and to exceed the powers intended by the legislature to be conferred on them. In passing such a clause, Parliament, it may be thought, was really stultifying itself, because, having inserted express provisions in the Act for the protection of persons liable to have their property taken without their consent, and having enacted that the Council in making and the Board in confirming an order must have regard to those provisions, it then, by means of this conclusive evidence clause, rendered such provisions nugatory, and, so far as victims are concerned, a mockery. Notwithstanding these criticisms from the bench, similar clauses have since been inserted in various other statutes dealing with compulsory purchase and compulsory hiring of land. The Housing, Town Planning, etc. Act 1909 in the first schedule contains provisions as to the compulsory acquisition of land by a local authority for the purposes of Part 3 of the Housing of the Working Classes Act 1890, which deals with the provision of working class lodging houses, and Class 2 of the schedule is as follows. An order under this schedule shall be of no force unless and until it is confirmed by the local government board, and the board may confirm the order either without modification or subject to such modifications as they may think fit, and an order so confirmed shall, save as otherwise expressly provided by the schedule, become final and have effect as if enacted in this Act, and the confirmation shall be conclusive evidence that the requirements of this Act have been complied with, and that the order has been duly made and is within the powers of this Act. The provisions of the first schedule to the last mentioned Act are applied by the Education Act 1918, Section 34, subsection 1, to the compulsory acquisition of land by local educational authorities for the purpose of any of their powers or duties under the Education Acts, with the substitution of the Board of Education for the Local Government Board. Section 16 of the Salmon and Freshwater Fisheries Act 1923 provides for the compulsory purchase or hiring of obstructions and fisheries by fishery boards by order, confirmed by the Minister of Agriculture and Fisheries, and subsection 5 of the section is in the same terms as Clause 2 of the first schedule to the Housing, Town Planning, etc. Act 1909 above, with the substitution of Minister for Board. So too the Housing Act 1925, which provides for compulsory purchase of land by local authorities by means of an order confirmed by the Minister of Health in accordance with the third schedule, for the purpose of providing houses for the working classes, contains a clause, Clause 2, in the third schedule which is in practically the same terms as Clause 2 of the first schedule of the Act of 1909. Under Section 10 of the London Traffic Act 1924, the Minister of Transport has power to make regulations to have effect in the London traffic area for relieving and facilitating traffic in and near London. Such regulations may provide for the suspension or modification of any Acts of Parliament, bylaws, or regulations dealing with the same subject matter as the regulations made by the Minister, or of any Acts conferring power of making bylaws or regulations dealing with the same subject matter. Subsection 3 of the section provides that any such regulations may provide for imposing fines recoverable summarily in respect of breaches thereof not exceeding in the case of a first offence £20, or in case of a second or subsequent offence £50, together with, in the case of a continuing offence, a further fine not exceeding £5 for each day the offence continues after notice of the offence has been given in such manner as may be prescribed by the regulations. And by subsection 6, the making of any regulations under this section shall be conclusive evidence that the requirements of this section have been complied with. The excuses which are offered even by the most able of the apologists of the new despotism are sometimes rather entertaining. It is said that Parliament simply has not time to do otherwise than delegate legislative power, that Parliament, even if it had the time, has not the requisite aptitude for the work, and that, after all, it is not the task of Parliament, but the task of the executive to govern the country. The last of these three propositions is said to constitute the greatest justification for delegated legislation. Now, to some onlookers, it may occur that if this threefold defence is really to be regarded as a fair and considered statement of the frame of mind which exhibits itself in the new despotism, nothing could well be more grave, for what does it mean? Let it be granted, for the sake of the argument, that there are matters of detail which can hardly be debated at length across the floor of the House of Commons. Let it be granted again, for the sake of the argument, that from time to time an Act of Parliament may involve technical matters which require careful and protracted consideration at the hands of experts and specialists. Neither of these circumstances, nor the pair of them in combination, can be said to afford the smallest reason why the work which is done should be done behind the back of Parliament, or without its knowledge and real assent. Nor do these, or any other circumstances, afford a reason why the order which is made, or the decision which is given, should be so contrived as to be beyond review in a court of law. As for the third of the propositions, if it contemplates anything over and above what in a particular emergency may be rendered necessary by sudden causes and occasions, or promptitude to meet the exigency of the case, it is not easy to imagine anything more mischievous or more subversive. True, it is indeed the task of the executive to govern the country, but it is the task of Parliament to make the laws, and the real business of the executive is to govern the country in accordance with the laws which Parliament has made. Is it not precisely because it is the task of the executive to govern the country that it is so dangerous to hand over to the executive the power of making laws as well, and of making them in ways which, while a kind of formal homage is paid to the sovereignty of Parliament, have the effect of employing the sovereignty of Parliament to oust the jurisdiction of the cause? Those who defend the system of departmental decision, without reasons given, without the possibility of appeal, and behind the back of the other party, are heard from time to time to say that it is cheap. Yet it may be much too dear at the price. They deplore the costliness of litigation. What they mean is that they do not wish the courts to stand between the departments and the taxpayer. Sunt lacrimae rerum, also crocodilorum. Things have their tears, and crocodiles have theirs. Litigation is not necessarily costly. Of course, if everybody at the same time insists on briefing one or other of a very small group of fashionable counsel, those favoured persons naturally, in order to protect themselves, increase their fees. Otherwise the burden of their work would be greater than they could bear. But there is no lack of ability at the bar, and there are scores of highly competent barristers whose fees are not in any degree exorbitant. Besides, it must occur to anybody whose opinion is not fixed beforehand that the argument based on the cost of litigation, even if it were sincere, would necessarily go much too far. If the taxpayer is not to be allowed to appeal from a departmental decision because the appeal might prove expensive for him, in what cases, if any, is an appeal to be desired? Nor is it necessary to elaborate the point that the excellence of a statutory right of appeal consists, not in multiplying appeals, but in encouraging decisions of such a kind that appeals against them will not seem attractive. The gist of the matter was forcibly and concisely expressed by Sir John Marriott in his article on Law and Liberty in the Fortnightly Review for July 1928. It is my profound conviction, he wrote, that the prevailing and increasing disposition on the part of the British Parliament to confer upon the executive quasi-judicial and quasi-legislative functions is wholly mischievous and ought to be resisted. The power of the Crown is increasing and ought to be diminished, so ran Dunning's famous resolution. Most of us would be startled if such a resolution were carried or even proposed in the House of Commons today. Yet if for Crown we substitute executive, there is at least as much ground for proposing that resolution today as there was in the third decade of the reign of George III. Closely connected with the subject matter of the present inquiry is the mischief arising from the obscurity of the language of so many statutes. To make a statute unintelligible is not the same thing as to make a departmental decision final, but either course may defeat the taxpayer. The obscurity of the language of statutes is matter for a separate treatise. It is due sometimes to ill-considered amendments, sometimes to the ambiguous use of terms, sometimes to a passion for simplifying the law by reiterating old expressions with new meanings. But above all, it is due to legislation by reference, and to the fixed and settled determination not to set out the matter clearly and completely. It is not many months ago since the revenue judge expressed himself pretty plainly in court upon the scandal of introducing bills or enacting statutes in the complicated and unintelligible form of many of the statutes referred to in the particular case. If he was bewildered as an expert in that very branch of the law, what must be the position of the ordinary taxpayer? The answer given by the law officer who was conducting the case for the Crown was illuminating. He said that it would not be possible to get the bills through the House of Commons in any other form. Now, this answer was not Machiavellian, nor probably was it intended to be facetious. It seems to have been intended rather as a bald statement of literal fact. In other words, the meaning appears to be that, if bills which impose or regulate taxes are to be got through the House of Commons within reasonable time, care must be taken that they shall not expose too large a surface for possible attack. Or, to put the matter more shortly, to be intelligible is to be found out, and to be found out is to be defeated. If this doctrine be true, it may be thought to throw an interesting light upon representative institutions and self-government, as in some quarters understood. Is it conceivable that a Parliament may some day arise which will refuse to pass lumps of undigested legislation, and will enact only that which it understands and definitely intends? If the output of legislation were in consequence smaller, it might not be a calamity. End of chapter 5.